The Supreme Court of Appeal yesterday dismissed an appeal made by Vodacom in relation to its fight with the inventor of the Please Call Me idea, Nkosana Makate. It held that Vodacom must pay Makate between 5 and 7.5% of the total voice revenue its Please Call Me product had generated over the past years, plus interest. Some estimates put Mr Makate's possible payday at around 20 billion rand. The dispute goes as far back as 2007, when Makate claimed that he had been promised compensation by Vodacom, given that he was the inventor of the Please Call Me idea. This morning, Vodacom came out with a statement to say that it will be appealing the matter at the Constitutional Court. So what are the implications of all of this? Well, I'm joined by Gary Booysen. He's a portfolio manager at Rand Swiss. A very good afternoon, Gary. Thanks very much for joining us. So this case has been simmering away for a number of years now. And even as Vodacom says that they're going to appeal the matter at the Apex Court, it's looking increasingly likely that Vodacom will be held liable to pay Nkosana Makate billions of rand in the double digits. Have we seen any dramatic moves on the Vodacom share price following the Supreme Court of Appeal's decision to dismiss Vodacom's appeal against Makate?
So there's hardly any impact on the share price. So I think this court case has been going on for a long time. It's been well telegraphed to the market, and I think a lot of the risk premium around it has been baked into the shares already. So we're currently down 0.22%, trading around 95 rand per Vodacom share. So no major impact based on the court decision. And I suppose this is heading to the Constitutional Court for the second time now. So still a way to go in this case as well.
Yeah. So if it heads, when it heads to the Constitutional Court, and should Vodacom not get its way and Makate wins, what would then be the implications for Vodacom, be it for their balance sheet, their share price, their management, etc.? What can we expect?
I suppose it all depends on the ultimate payout size. So already, a lot of people looking at the 47 billion rand that's been offered as incredibly generous. But obviously, Makate is saying that this needs to be looked at over 20 years, not 5 years, as Shamil Yusuf looked originally. He's looking at the 20-year period specifically because that's how long a patent could have been enforced. There's all sorts of debates about around the patent and whether or not that's fair. But, the initial claim that he was making was around 20 billion rand. I mean, that is just an absolutely astronomical figure. It's more than 10% of Vodacom's market capitalization. And, the idea that, I suppose the idea that an idea would be worth 10% of Vodacom currently, it does seem just crazy. So it does seem like, it's going to come down to the final settlement. If it's 10% of Vodacom's market cap, I mean, the ramifications, not just for Vodacom, but for the overall market, would be severe. It would be a real blow to the private sector in South Africa. You would see the share price down significantly and probably more than the actual monetary value, because it would mean that essentially ideas which technically have no ability to be copyrighted and have no IP protection could result in significant financial impacts on all corporates, and that, I mean, that's a huge precedent to set. So a very, very dangerous precedent to set. So it does come down to the ultimate value, and that's at this stage is still very, very difficult to determine.
Very interesting arguments that you're discussing there. So what do you think corporates can learn from this particular fiasco, whichever way it goes, from an intellectual property type of perspective, especially because this guy worked in a completely different department. He wasn't in an innovation center or whatever. He just came up with an idea, and subsequently he was promised compensation for coming up with the idea, which of course helped to generate billions of rand for Vodacom.
Yeah, so I mean, it's a great point. It's a very interesting case, because at the face of it, you think, how can this even be in court at this stage? You look at it, and I suppose it all comes down to how much is an idea worth, and how much is the execution worth. There's already questions around MTN being the original inventor of the Please Call Me, did he just come up with an idea? He didn't help to develop or launch the product, and in isolation, could he have achieved these kinds of revenue figures? Ideas are great, but without execution, ideas don't turn into anything. So I think the message to corporate South Africa, and it's a message that I think the Constitutional Court is going to have to send, is it's how much can an idea be protected? And that's, I mean, it's incredibly important just for I suppose, the rule of law in South Africa more than anything else. So, it's an incredibly interesting case. But at this stage, I think corporate South Africa, one, has to decide, when you're promising compensation, who is promising compensation, and can that compensation actually result in a monetary commitment by the company? So the manager, who was Philip Geisler, when he said you can have a share of revenue of MTN, was he in a position to actually make that sort of promise? And corporates have to be very, very careful about those types of promises and the promises that they make. And I think you've got to look at the overall. You've got to look very carefully at the overall investment environment in South Africa. That if this type of intellectual property right can be protected, it makes the playing field very, very difficult for corporate South Africa, and it actually makes South Africa worse as an investment destination. So, as I said, I think it's going to be very interesting to see what the Constitutional Court rules, and I think it's going to be a very important decision.
Absolutely. Gary, we're going to leave it there, but thank you very much for your insights on this issue. Gary Booysen, he's a portfolio manager at Rand Swiss.